Hello. Nice to see you.
Nice to see you. How are you?
Thanks. I'm okay. And you?
I'm fine. So the last seminar.
And it is in Hungary. It is summertime.
Summer.
Yes, it's so warm.
In Warsaw, it's quite okay. It's warm.
But at the end of the week, it will finish, and the fall is coming. The autumn is coming.
I see we have Nora, Paweł, Wojciech,
Yes.
but
Hello.
hello.
Hello, Wojtek. Hello. New room.
Yes, my room where I sleep and work from time to time.
Nice, so nice.
Thank you for your article, Wojtek.
Yes, okay.
I asked director, and we can submit our article to the end of October.
Oh.
If you need the time.
Oh, it's a good news, but I finished today.
Okay.
I finished today. I finished today. I thought
it's the last time. The last seminar.
Yes.
Yes. And Kaja, do you confirm that can we take part at the big conference online in November?
Hi.
Yes. Hi.
Hi.
I asked only about Nora, but yes, they confirmed that she can take part online. But if you want, of course, yes, I confirm for you also.
Not the dissemination event.
Yes, I understand.
But
this
the
conference.
Yes, in Poland, because I planned to go to Poland, but I had an invitation on Friday, November 17, and I won't be able to come back, and I would like to take part on this conference on Friday. So I this is the only way I
so I confirm and I let you know, okay?
Okay.
Because I asked only about one person, but probably won't a problem.
Hi, Marty.
Hi.
Hi.
You are waiting for Nora.
I'm here.
Oh.
Hi.
Hi. Hello.
Hi.
I asked Dr. Więckowski, Nora, about this provision. You asked about report until 15th, yes? Yes, and he told me that it's only article. This provision is, it applies only to article.
Okay.
So we don't have another report.
Okay, so but I have read it in the contract that we have a final report, and only that's why. But if you say that it's the article, then it's okay.
Yes, because I checked my agreement. Yes, and there is some kind of provision about report until 15th. Yes.
Okay.
So and I thought the same. Yes, but he told me that it applies only article.
Okay, and in the article we can summarize what we have searched.
Yes.
Okay. Thank you. Thank you.
So we can start. So good afternoon. I warmly welcome you all to the last seminar with our project Legal Protection of Children with Disabilities, organized by the Justice Institute. Since the seminar is open to the public, I will introduce myself one last time. My name is Katarzyna Roszewska. I'm an associate professor of law at the Cardinal Stefan Wyszyński University in Warsaw. Today we will summarize our research under common title Conclusions lege lata and postulates lege ferenda on the rights of children with disabilities. Members of the research team will present their conclusions. They will speak in order: Professor Wojciech Lis, Legal Subjectivity of Disabled Child; Dr. Paweł Zając, Conclusions lege lata and postulates lege ferenda on the right to social security of children with disabilities in Poland; me, Conclusions and postulates on accessibility as a condition for the full implementation of the rights of children with disabilities; Professor Nora Jakab, Conclusions lege lata and postulates lege ferenda on the right to social security of children with disabilities; and Professor Zuza Wopera, Conclusions and lege ferenda proposals to improve the procedural legal status of children with disabilities; and Dr. Marta Benius, Conclusions and lege ferenda proposals to improve the effectiveness of application on the principle outlined in the CRC, with a special regard to the right to life and survive in a loving family environment in terms of disabled children. So first to speak is Professor Wojciech Lis. Please, Professor, the floor is yours.
Thank you very much. Welcome, everyone. This time, I want to focus on showing that a disabled child is a full legal subject. I admit that this issue seems to me to be a matter of fundamental importance. To analyze the issue of a disabled child, it is necessary to determine its legal status and the resulting consequences. It is even more important to indicate the axiological foundations that constitute the source of human rights. It is natural law, timeless, universal, pre-state, and independent of a human legislator. Such a right is inherent in every human being, regardless of any of his or her characteristics or properties. Enriched with a concept of human dignity rooted in Christian humanism, it requires treating every person equally. Dignity is inherent and inalienable. It cannot be removed or taken away. This is particularly important in the context of the issue of legal personality of disabled people, including a disabled child. Human dignity, which belongs to him by the mere fact of being a human being, gives rise to his subjectivity. However, human subjectivity is not subject to any gradation due to its source. Human subjectivity is a feature of every human being. His health or fitness level has absolutely no importance here. This means that every person, regardless of physical or mental condition, is the subject of human rights. In other words, I am a human being. It means a subject, so I have rights. However, the free disposal of these rights, which is related to a person's age and mental condition, is another thing. A child has all human rights, but begins to enjoy some of them only after reaching the required age. Every human being has legal capacity, which means that he may be subject to rights and obligations. This means that he can be the owner of a flat because he such a right, and at the same time be obliged to bear the related costs because he has such an obligation. The ability to independently shape one's legal situation by performing legal acts, mainly by concluding contracts, is defined as legal capacity. This property is gradable. Only adults, that is those over 18 years of age and not incapacitated, have full legal capacity. Thanks to this, they can perform all activities permitted by law aimed at acquiring a right, disposing of a right, or incurring an obligation. For example, sale of real estate, preparation of a will, conclusion of lease agreement. People under 13 years of age and completely incapacitated people do not have legal capacity. A legal act performed by a person who does not have legal capacity is, as a rule, invalid. That is, it does not produce any legal effects. Children between 13 and 18 years of age have limited legal capacity. For the validity of a legal act by which a person with limited legal capacity disposes of his or her rights or assumes an obligation, the consent of his or her legal representative, usually a parent, is required. This reservation does not apply to contracts commonly concluded in minor, current matters of everyday life, which persons with limited legal capacity may conclude without any restrictions. This reminder is important to emphasize that disability is not a circumstance that deprives a child of a legal capacity unless the disabled child has been completely incapacitated after the age of 13. I want to say that disability, as a rule, does not reduce the rights that children normally enjoy. Of course, he often needs support from other people, but it cannot lead de facto to incapacitation of the child due to his disability. Meanwhile, parents terrified by the fact that their child has a disability take excessive care of the child, do it for the child, and take over activities that the disabled child could cope with. Such help not only slows down and sometimes even inhibits his development and willingness to overcome his limitations, but also limits his autonomy and independence. As a result of this approach, the child is reduced to the role of an object because he does not do anything around him, does not make any decisions, does not become independent, is subject to adult influence, and can be freely controlled. Therefore, it is believed that children with disabilities to have no control over their own lives. This objective approach to a disabled child limits him not only in making choices and decisions, but also in his right to reveal and show negative emotions and feelings. Moreover, it leads to a state of helplessness and dependence on the help of others, and arouses demanding attitudes, which leads to escalation of expectation and demands that others meet their various needs. Such behavior of the parents of a disabled child is contrary to the principle of the child's best interest. In a subjective approach to the child, there can be no question of deciding or imposing one's will on the child, even if it is with the best intentions. Supporting a disabled child does not mean replacing him in deciding about himself, making choices, presenting his position, or doing activities that he could successfully do on his own. A subjective approach to the child is the key to his independence. Only treating the child subjectively will protect him from rejection, labeling, or isolation from the social environment. However, treating a disabled child as an object only expands the scope of his independence. This is part of a general tendency to treat them seriously as subjects of law or subjects of law, and not as objects of influence, as full members of the community, and not as an unnecessary burden to be supported by society. Disability is a common phenomenon in human life. There are many factors causing disability. Some are congenital, others are acquired throughout life. The reasons for disability may be accidents, diseases, life situations leading to the activation of various forms of mental or physical disorders, or the passage of time. Virtually every person at any time in their life can become disabled. Therefore, disability should be treated as something normal and part of human life. For this reason, every person, despite their disability, has the right to be treated subjectively. Disabled people are not objects to be managed, but entities with the entire package of rights inherent in humans. To sum up, in order to see a disabled child as a legal subject, all children should be prepared to accept their own and other disabilities as a part of life, present or future. The best way to achieve this is constant contact between able-bodied and disabled children, thanks to which the children learn their differences from each other, but also learn to help each other, tolerate each other's limitations, and perceive them as full members of one community whose fates are intertwined and who depend on each other. This only emphasizes the importance of education to overcome prejudices. Simply establishing the rights of disabled children will not solve the problems arising from disability. It is necessary to create appropriate conditions for the realization of these rights. And the best way to achieve this is through education combined with the experience of disability. Thank you very much for your attention. Thank you very much. Katarzyno, musisz włączyć mikrofon.
Sorry. Thank you. Thank you, Professor. And now I would like to ask Dr. Paweł Zając. Please, Doctor, you may start.
Thank you very much. My name is Paweł Zając. I'm assistant professor at Łomża University. And today I would like to summarize my research about social security of children with disabilities in the Polish legal system. We all know that children with disabilities constitute a very delicate but also important fabric of a society. Therefore, in order to realize their basic rights and to counteract their social exclusion, public administration bodies are obligated to provide them with appropriate and decent condition of existence. This obligation is fulfilled by ensuring their social security, the essence of which is the removal all of barriers that would prevent them from achieving their life aspiration. Ensuring social security for children with disabilities require a holistic approach that takes into account their individual needs and aspiration and involves society, educational institution, and guardians in the process of supporting these children. My research, conducted as a part of the ongoing project, focused on selected issues, analyzing the provision contained in the Polish legal system, as well as in 10 other legal systems like Hungary, Germany, Great Britain, Romania, Spain, France, Sweden, or Finland. Below, I would like to present the lege ferenda postulates that appeared in connection with the research conducted, relating them to the individual topics that constitute the subject of my analysis. First of all, I analyzed international humanitarian law, which in particular, in the Fourth Geneva Convention, provides for special protection for children under the 15 years of age and orders the parties to the conflict to give the special treatment to this social group. In the field of the disabled people, appropriate regulations are included in the additional protocol, which give them the status of wanted, obligating states to provide them with assistance, create special sanitary zones, and refrain from any actions toward them. However, as the conflict in Ukraine has shown, despite the existing of specific legal guarantees for children and disabled people during armed conflicts, the parties of the conflict often do not comply with the provision of the convention, making humanitarian law a set of wishful thinking. There is therefore a need to greater law enforcement. It is worth emphasizing, however, that Poland was the initiator of the adoption by the United Nations Security Council of a resolution on the protection of persons with disabilities during armed conflict. However, the resolution itself was not followed by any legislative action, either at national or international level, leaving this issue in limbo. The next issue concerned health protection. The analysis of regulations regarding the health protection of children with disabilities has shown that the Polish authorities implement the provision resulting from international obligation. Children with disabilities are a category of entities covered by special protection in this area, as especially indicated in the Constitution of Republic of Poland. The law provides for a number of solutions that facilitate access to healthcare, services guaranteeing them free benefits include in the scope of guaranteed benefits free dental care, free rehabilitation, and co-financing for rehabilitation equipment. The disadvantage is the very structure of the healthcare system and its financing, which means that the waiting time for a specialist can last up to over a year. Moreover, the most expensive health services are not co-found, which force parents of children to look for other sources of financing, such as public collection. The social assistance system for children with disabilities also deserve a positive evaluation, especially in the face of the change that took place at the end of the August this year. After the changes, the nursing benefit will be available to parents or other persons taking care of children with disability up to the age of 18 without any restriction on taking up employment or other gainful work. An important change is also the introduction of a higher amount of the care benefit if there is more than one child with disabilities in the family. If a parent or a guardian takes care of more than one child with disabilities, the nursing benefit will be increased by 100% for the second and each substance child with disability. In this respect, Poland is one of the few countries that have abolished the income criterion. As a lege ferenda request, it is possible to consider increasing the tax relief for children with disabilities, which currently amounts to approximately 1,200 zloty per year. It is also worth considering adapting, following the example of Germany, the possibility of introducing a tax relief consisting in the possibility of deducting free curtain of the cost related to the childcare if it entrusted to a caregiver, or the cost related to a boarding school and stayed in special schools. Another issue analyzed was cyberspace, which has become an indispensable element of our lives. Despite the many benefits it can bring, it's also a dangerous place. The virtual world can become an invaluable tool for children with disabilities, helping them integrated with their peers and society as a whole. It can be used for education, broadening your horizons, and entertainment. However, in order to achieve these goals, countries should adapt appropriate regulation to protect children, including against hate speech, cyberbullying, and sexual abuse. Current regulations in Poland do not fully protect children with disabilities, an example of which is the exclusion of disability from the crime of hate speech as a discriminatory ground or the lack of a codified crime of cyberbullying, which means that the parents who want to protect their child have to wade through the thicket of regulation when looking for appropriate legal protection. Therefore, it may be surprising that despite repeated recommendations of the Polish Ombudsman, as well as eight proposals to change the regulation in which the catalogue of discriminatory grounds were extended, the Polish authorities do not see the need to protect people with disabilities. An example for the Polish legislator may be the solution adopted in Hungary. Moreover, it is worth considering whether to adopt a national strategy for the protection of children with disabilities in cyberspace, as was done, for example, in Great Britain. Services related to public transport for children with disabilities were also analyzed. In this respect, they, together with their guardian, benefit from discounts or exemption from public transport fee. This issue varies depending on the municipality. However, the education law provides for free transport to kindergartens and schools for children with disabilities, organizing special transport for them. Moreover, it is possible to ask the commune for a refund of the cost of such travel if the commune does not provide free travel. An interesting solution worth attention is the car allowance adapted in Sweden for the purchase or adaptation of a car or other vehicle to the needs of the people with disabilities. The above analysis is only a small part of the issues related to ensuring social safety for children with disabilities. However, it already allows us to state that the Polish legal provisions do not differ from the standard of protection of children with disabilities in the respect adopted in European countries. However, anti-discrimination provisions remain a shortcoming, in particular in the field of protection in cyberspace, which hinder the full implementation of international obligations. Thank you for your attention, and I'm glad that I could be a part of such an estimate research group. Thank you.
Thank you, Doctor. You talked about many different topics, but I think the status of refugee children, it's still very urgent, yes, when we see what's happening between Israel and Palestine. So not only in Ukraine. Now it's my turn to present the conclusions of the study. So we know that for centuries, persons with disabilities have suffered social oppression based on historical, religious, socio-economic patterns. Among them, children with disabilities were particularly vulnerable to abuse, violence, and discrimination. And nowadays, there is no doubt that children with disabilities are human rights holders on an equal basis with other children. And we have walked the long path from the first declaration of 1924 to the Convention on the Rights of the Child. It's worth highlighting what we already know, that CRC, Convention on the Rights of the Child, was the first human treaty that contained a specific reference to a disability and a separate article dedicated to the rights and needs of children with disabilities. If you remember, accessibility was the next step in the development of the human rights to equal treatment and non-discrimination. I invoked in this context the Vienna Declaration and the Standards Rules on the Equalization of Opportunities for Persons with Disabilities, both from 1993. It's obvious that a disabled person can lead a normal and successful life. If so, how we support children in their childhood affects their development opportunities in all areas of life. I considered legal standards, try to present the origins of accessibility in international law and show the way of developing the contemporary model of human rights. I presented the struggle of parents for access to education, also showed a group of people educated in the medical model, which leads to segregated employment. And in contrast to them, the successful people in discipline not obvious to people with disabilities like sports, science. There were Oscar Pistorius and Professor Stephen Hawkins, and they were disabled from birth or from an early age, as you remember, but they were educated in regular schools. Disability doesn't have to mean a poorer quality of life, and these examples showed the importance of accessibility even before we started discussing it as a principle of international law. And due to the research objectives, my study didn't take into account the full context. It only outlined the international and national perspectives, focusing on the role of the principle of accessibility in the implementation of children's rights. The subject matter involved seeing primarily from the perspective of two UN conventions, the rights of the child and on the rights of persons with disabilities. And Article 23 of CRC, aimed at the protection of children with disabilities, provides for the obligation to ensure a full and decent life in conditions that promote self-reliance and facilitate the active participation in the community. This article is one of the few provisions to which no reservations or declarations have been made by states parties. However, the rights of children with disabilities still didn't receive due attention. And the provision itself sometimes have been even seen as the convention's pretty ornament. Also, the language of the provision was firmly rooted in a medicalized approach. It emphasizes special care, treatment, rehabilitation. It was suggesting a tendency to treat children as primarily requiring protective measures rather than as active rights holders. While the CRC is an act that dates back to the welfarist understanding of disability, the CRC committee has repeatedly stated in its conclusions observations that the state parties must adopt a human rights-based approach to disability. Also, in general comment number 9 on the convention, the committee deplored the exclusion of children with disabilities from society and urged state parties to invest in the maximum inclusion in society to the maximum extent of available resources. However, the conclusions, concluding observations and general comment do not have the same binding effect on the state as the treaty provisions do. So the solution was the Convention on the Rights of Persons with Disabilities, sometimes even called Convention on the Rights of Children and Adults with Disabilities. And this treaty, this convention, provides a remedy for the twofold vulnerability related to age and disability at the same time. So strengthens the visibility and presence of children with disabilities within international law. It imposes clear obligations on state parties to take measures that remove barriers faced not only by persons in general, but especially by children based on both their disability and childhood. The CRPD explicitly refers to the rights of children with disabilities in several places, in the preamble, in the general principles, in general obligations, and in specific provisions on freedom from exploitation, freedom of movement, citizenship, respect for home and family, education, health, participation in cultural life, leisure, and sport. At other times, the convention requires also to take into account the age-related needs. This means that the states must take measures that respect the childhood and age of children when implementing the rights enshrined in the CRPD. The Committee on the Rights of Persons with Disabilities has not yet commented on the provision of Article 7 in its general comment. Still, it has expressed its view on several occasions in concluding observations addressed to the EU, among others, and in this, it pointed to the need for a comprehensive strategy, policy, law that facilitates full integration of children with disabilities into all aspects of the community and life. The accessibility is one of the most significant provisions of the CRPD. It's not only to set the direction of the states and to interpret the specific rights. It's not just a principle, but a general right that affects other rights guaranteed to children with disabilities. Emphasizing accessibility as a fundamental principle involves recognizing its role in the Convention. The other provisions must be interpreted and implemented in accordance with it. Each of the rights of children with disabilities is reinforced by the principle of accessibility, and the full enjoyment of human rights means ensuring access to all their rights in all areas of life. The accessibility is inseparably linked to all the rights set out in the Convention. All the rights, guarantees, protection mechanisms established under CRPD apply to children with disabilities. At the same time, the rights enshrined in the CRC, in the Convention on the Rights of the Child, have to be read now, taking into account the guarantees under the CRPD. Specific consequences for member states have been caused by the adoption of the Convention by the EU. In the opinion of the Court of Justice, without questioning, of course, the validity of the earlier equality directives, these directives should, as far as possible, be interpreted in accordance with the Convention, which forms an integral part of EU law now. In turn, EU membership involved also Poland into the EU common policy on persons with disabilities. And now about Poland, the Polish constitutional standard for the rights of children is based on a welfarist approach. The child has the right to care and assistance from public authorities, and constitutional standards for persons with disabilities is even poorer than that. Public authorities should provide assistance to this person in securing the existence, preparing for work, communication, and they are also obliged to provide them with special health care. However, Poland is bound by international standards for the protection of human rights, including the protection of children with disabilities, which have been the impetus for many legislative changes. Unfortunately, the revised version, for example, of the European Social Charter of 1996 and the optional protocol to the CRC on the notification procedure still await ratification. Poland has also omitted to sign the optional protocol to the CRPD. The statutory regulations concerning children with disabilities, like the issue of disability assessment, special educational needs, accessibility, other disability-related rights, are very much fragmented in our law. Several public institutions are competent for different areas of the implementation of these rights. Attempts to coordinate them at the central level have been unsuccessful, despite the existence of such a body as the government representative for persons with disabilities. Coordination regarding accessibility of public entities has recently been undertaken by the Minister responsible for regional development on the Act on ensuring accessibility to persons with specific needs. And this act sets out measures for ensuring accessibility to these persons and the obligations of public entities. The law certainly will contribute to the improvement of the accessibility in public institutions. However, the legislature didn't organize the legislation in the area of accessibility law, and only to a narrow extent does this law apply to private sector. My recommendations are motivated by the recommendations of the UN committees, Committee on the Rights of the Child and on the Rights of Persons with Disabilities, as well as by the identified gaps in Poland's implementation of the accessibility with regard to children with disabilities. I submitted the lege ferenda demands for public policy. The lege ferenda requests, such as to implement accessibility in accordance with Article 9 of the CRPD and the General Comment number 2, especially number 2 on accessibility, to adopt accessibility standards at national and regional level, to implement the European Disability Act, to ratify the European Social Charter, revised version of 1996. We signed this version, but Poland has not still ratified it. To ratify the optional protocol to the CRC on the communication procedure, also sign and ratify the optional protocol to a CRPD. So it means we have a poorer standard than Hungary in this context, to reform the disability and special educational needs assessment systems. And as postulates for public policy towards children with disabilities, I suggested to identify existing gaps in all areas of accessibility that impede the enjoyment of human rights by children with disabilities, to clearly define the responsibilities of the various authorities, including regional, local authorities and private sectors, that should be exercised to ensure accessibility for children with disabilities. Identify the children as a group in all strategies, all policy papers that affect them, especially the disability strategy, and we should also implement the EU strategy on the rights of the child. Support families of children with disabilities, of course, in line with the human rights paradigm adopted in the CRPD. And finally, to collect data on children's disabilities according to Article 31 of the CRPD. The Polish Central Statistical Office expanded the areas of research a few years ago and included the area of disability. However, the data collected is still selective and too general. And that's all. Thank you very much. It was my last presentation in our project, and it was a big pleasure for me. Now I would like to ask Professor Nora Jakab with her presentation on the conclusions the lege, lata, and postulates, lege, ferenda, on the right to social security of children with disabilities. Please, Professor, the floor is yours. Do you need some help with your presentation? No, we can see.
Can you hear me?
Probably your desktop.
Now I think you can see my presentation.
Yes.
Okay, please don't be afraid that it's 65 slides. I'm not going to go through entirely, but it shows and presents.
But can you switch your microphone?
I have done.
But
can you hear me?
We barely hear you.
Okay, because of the bad connection.
Most semmit se lehet hallani, Nóri. Semmit.
To be on mobile. Can you now hear me?
Yes, it's okay.
Yes.
I can't hear you. Now?
Yes.
Please say something. Okay.
Yes, everything is okay.
I have a very, very bad connection. Okay, I have got 65 slides, but I'm not going to go through all the 65 slides. It is just the report of the work that I have done. And this work was based, as you know, on the social security issues of disabled children. And first, I have tried to analyze the situation of disabled children. And the right to social security is not yet a reality for some 71% of the world's population that has no or has only partial access to comprehensive social protection system. So it is really a problem worldwide, what kind of quality of living we can provide for the people. And when we are talking about vulnerability, then I think that disabled children are maybe the most vulnerable because they are very much dependent on the families. And it is really true to the social security system as well, because their services which they are provided are really linked to the family and to the caring adults. They can be the real parents or foster parents. It varies, of course. And after the analysis of the situation, I went a little bit deeper, and I have tried to analyze some basic principles regarding social rights, the importance of social rights, and also the nature of social rights. And after that, social security has been a little bit reviewed. And it was also important that what is really the right to social security. In reality, there is no such guarantee in the constitutions for the establishment of the right to social security. And the reality is that the sick, the starving, and the disabled are legally guaranteed a certain existential relief, but they are not guaranteed, cannot be guaranteed real social security. And actually, these are the basis. And after that, I've looked at the international legal framework. And in the international legal framework, I have found the International Covenant on Economic, Social, and Cultural Rights, and also the ILO Social Security Convention number 102. And after that, the revised European Social Charter, and I have also found some peculiarity like American Declaration of the Rights and Duties of Men, or the human rights in the area of economic, social, and cultural rights. And of course, in the focus, I had two very important conventions. One of them was the CRPD, And I have seen that in the CRPD, this Article 28 relates to the right to social security, not particularly to the disabled children, but of course, disabled children are addressed in the convention in many places, as you can also see. And the CRPD, besides the CRPD, of course, I've been also dealing with the Convention on the Rights of the Child, and I have tried to focus on the Article 26, which is the right to benefit from social security measures. And of course, I have looked at all the articles which are related to this right. And what I have seen on the CRC and the CRPD, that they are really rights which must be established in a sort of progressive way. When I looked at the right to social security in each conventions, I have just noticed that this right to social security is very much a complex issue and actually a holistic issue, which is in connection with so many other articles. After that, you can see I've been dealing with, just a moment, with the Hungarian approach towards the social rights. And in this section, I have provided you with some information on the previous fundamental law and the fundamental law of nowadays, how the fundamental law approaches the right to social security. And there is a very high critic from many constitutional lawyers that the level of the support has been decreased, but I have been made some interpretation on the view that actually it is the role of the Constitutional Court to make in its decisions real the right to social security and to prove that the level has not been decreased, it is still the same. I found it important because it has been the basis for the analysis of the Hungarian social security system and social services regarding disabled people and disabled rights. And after that, I have looked at the international literature, which was focusing on the analysis of the social security system and more generally on the social protection of disabled children and disabled people. And I have tried to found some of the characteristics, and you can see the criteria for the child-sensitive social protection. And social security is within this system, but it is only one part of it. I also find important to have a look on the I'm showing you on the reporter view, because there was a general comment on Article 26 of the CRPD, and the general reporter talked about the element of the social security system as well, which must be established in a country. And after that, I think there is another important issue as well, but unfortunately I cannot see really well. And you can see what the inclusive social protection means, what kind of elements it combines. And I found this analysis important because after having looked at social rights, the right to social security, the international legal framework, and having seen the general thinking about the importance of social security and what it is like, these are the criteria that we can compare the Hungarian or any other country social security system. And then when we looked into the social security system in Hungary, then I have collected, you cannot see really well, all the benefits in cash that are provided for the disabled people. I also looked at the entitlement criteria as well, but I don't think that it should be really in the focus of this research. I have also looked at the benefits in kind, other forms of support, and I also looked at the personal care benefits. And from all these, I have also looked at what are the services which can be as subject of the right to benefit from the social security system. And in Hungary, we can see that we have got quite few insurance-based, but a lot means-tested benefit. And of course, if we have got lots of means-tested benefits, then it has its consequences. And the conclusions were that in cash in kind and personal care, this means-tested benefit will really show us that we have got a very low level of financial support of which disabled children and disabled children's parents are provided. And it has been a question for me whether this is enough for an adequate living or an adequate way of living. You can see that disabled child or disabled children are protected mainly by services offered to the family. We can find not so many services related only to the disabled child. And in terms of legislation, the child protection and this legal environment is quite stable. But when we talk about child protection, then it is different than the social security system. Although during the research, I also dealt with some issues of the child protection system. We have got a changing non-regulatory environment in this field, which is very difficult to be followed. And there is a particular shortage of foster parents, but it is also a question of the child protection system. However, it has got consequences because when we have got this trend, then it means that the institutionalization is still very much in the focus, and the level of the way of living in these institutions are not so adequate. When we look at the personal care benefits, for example, when we have got many housing services, that kind of services does not have a very high quality. And as conclusions, I have went through the theoretical basis that I have looked at. It was one of them was this code inclusive social protection system. I have tried to make some summary about the Hungarian situation. But for the lege ferenda, and it might be not so good to see because you have got this, but now maybe it's better. I have looked at the child-sensitive social protection criteria and tried to make a mirror to the Hungarian system. And as a consequence, it was obvious for me that the lege ferenda, it's very important that, okay, we have got child-sensitive social protection system, but it would be much more important if we analyzed this in a different way. Therefore, I did not agree with that recommendation on what child-sensitive social protection means, because it should have 5 other elements. And of course, it must be understood in a holistic way. Okay, social security system is one part of it, and you can find it mainly in the first part, because it should be a combination of means-tested, insurance-based, and personal care benefits. But unfortunately, we cannot say that it should be like this and this and this, because how the social rights are realized is really dependent on the financial situation of the state. Of course, we need a family-friendly labor regulation. We need gender inequality, and it's very important that we need the equality of the different working forms, not only self-employment, but also the employed, the dependent employed should be treated in the same way before the law regarding services as well. Unfortunately, self-employed, and if, for example, if a self-employed has a disabled child, they pay very low contribution to the social security system, and they cannot enjoy even that kind of level of protection that is provided now. Of course, we need stable and effective child protection scheme. It's a different part, and we need tax, financial, and employment policy decisions. And of course, we have got some roots also in the, and some patterns also in the Hungarian legislation. So I made, as the lege ferenda, different approach, or maybe slightly different approach, how this social protection system, including the social security system, should look like. So thank you very much for your kind attention, and it was a pleasure having you for such or for so many months. Thank you very much.
Thank you very much, Professor, for such a deep explanation how the Hungarian social care system works. Now we speak Professor Zuzana Vopera on the conclusions and the lege ferenda proposals to improve the procedural legal status of children with disabilities. Please, Professor, you may start.
Thank you so much. I would like to say sorry in advance because of my connection is very bad, but when you were speaking, it was better than earlier. But I hope that you will listen to me. So in my today's last presentation, allow me to summarize the findings of the second study and tell you my lege ferenda proposals. The title of my lecture is Conclusions and the lege ferenda Proposals to Improve the Procedural Legal Status of Children with Disabilities. In 2015, a report on access to justice for children with mental disabilities, international standards and research results in 10 European countries, hereinafter report, was published, which examines, among other, the procedural status of children with disabilities in 10 EU member states. One of the member states was Hungary. The report presents a negative picture of the procedural legal status of children with disabilities. One of the most striking findings of the research is that the justice system is completely or largely missing data that shows how many children with intellectual or mental disabilities come into contact with the justice system, and that would show the type of disability and data on the outcome of the proceeding. Although each state is involved has human rights monitoring system, this marginalized group of children is rarely in the focus of their attention. In Hungary, establishing contact with children with disabilities is also quite difficult, as many courts and offices are still not barrier-free. In addition, judges do not receive training on how to communicate with a visually impaired or hearing impaired or intellectually disabled child. Despite the negative processes, in recent years, I think that there have been many positive developments in the field of broadening of the right of children to express their views, including the participation of children with disabilities in civil proceedings. I would like to summarize these positive tendencies, focusing the possibility of further developments of this institution. So we agree with the findings of the above-mentioned report, makes the following recommendation in order to improve access to justice for children with mental disabilities. Legislators should develop national plans that show how the rights of children with disabilities can be achieved. It's important that the following principles are the main drivers of these plans. Freedom from discrimination in accordance with the Article 12 of the CRC, Article 2 CRPD, Article 3, and Article 5. The second is the best interest of the child in accordance with the CRC, Article 3, Article Paragraph 2, the CRPD. The third is the recognition of the developing abilities of the child. In accordance with CRC Article 5, CRPD Article 3, equal protection and benefits provided by the law in accordance with CRPD Article 5, and social participation and inclusion in accordance with CRC 12. The report emphasizes that the procedural rules and rules of provisions of taking of evidence of the national legal system must be amended because they do not attach sufficient importance to the testimony and statements of children with intellectual or cognitive disabilities, and they must help the child to express his or her own views and preferences. It follows that legal proceeding must reach a certain level of flexibility to be able to meet the needs of each child at the same time, and the provisions for individualized appropriate assistance. Available forms of assistance should include sign language, augmentative and alternative communication, including interpreters trained to communicate with children with mental disabilities, and all other forms, tools, and methods of communication chosen by the child with mental disabilities. As soon as a child comes into contact with the justice system, an individual survey must be conducted. This ensures that children themselves have a role to play in the decision-making process and are fully involved in the assessment of the best interests through provision of reasonable assistance where necessary. Despite of the difficulties in the field of access to justice for children with disabilities, there were clearly forward-looking steps in Hungarian legislation and judicial practice in the recent years. As I mentioned earlier, the Civil Procedure Code contains precise procedural rules for the hearing of minor children as an interested person in actions related to personal status, which I consider to be a very forward-looking provision, I think. I should be mentioned that the Hungarian courts have the so-called children's hearing room, where a minor child can be heard by the court in a suitable atmosphere. Children under the age of 8 to 10 are typically heard in this children's hearing room. Older children prefer to be heard in the courtroom. These children's hearing rooms are suitable for the courts to hear older but mentally disabled persons, for example, children with Down syndrome. And it may also be suggested that the hearing of an adult person, but who is mentally disabled, will also take place in this friendly environment. Section 113 of Civil Procedure Code guarantees that persons with hearing difficulties and deafblind person shall be entitled to use sign language or another special communication system specified in the Civil Procedure Code and known by the person concerned. At request, persons with hearing and speech disabilities may submit a written statement in place of a hearing. According to the section 61 of the Civil Procedure Code, the court shall assign a sign language interpreter if doing so is necessary to enforce the rights specified in the above-mentioned section of the Civil Procedure Code. This provision shall also be applied in the case of hearing a disabled child as an interested person. So in order for hearing impaired or deafblind or speech impaired parties and other persons to be able to exercise their legal rights and fulfill their obligations without restriction, the Civil Procedure Code regulates several solutions. In this regard, the Civil Procedure Code specifically provides for the use of sign language in the case of hearing impaired or deafblind person, which is highlighted in the fundamental law by the fact that according to the paragraph 3 of Article 8, Hungary protects the Hungarian Sign Language as a part of Hungarian culture. In addition to the use of sign language, the Civil Procedure Code also allows the person concerned to use other special communication system known to him defined by law. A hearing impaired or speech impaired person may, if he so requests, make a statement in writing instead of hearing, as I mentioned earlier. The other positive legal institution that can be further developed is the Children's Right Representative. According to the Section 11 of the Child Protection Act, the Children's Rights Representative ensures the protection of the rights of the child receiving child protection care. So it is not in the civil proceeding, but it is in a child protection care system. The children's rights representative pays special attention to the protection of children who require special care. The child rights representative, for example, helps the child to formulate its complaint, can initiate its investigation or procedure, help the child in accessing care appropriate to his condition, as well as in formulating related comments and questions at the hearing held by the guardianship authority. The children's rights representative is entitled to request information, documented information in the operational area of the child's welfare or child protection service provider, and to obtain information on the spot. The child rights representative is obliged to handle the child personal data in accordance with the data protection legislation. The children's rights representative is entitled to meet the child personally at the time initiated by him without the presence of the head of the child welfare and child protection service provider or his staff, including the foster parents. The child rights representative is employed by the ministry. In my opinion, there are plenty of development opportunities in the legal institution of the children's rights representative. It would be necessary to extend the authority of the child rights representative to protect the rights of disabled children in civil actions and in guardianship proceedings, even if the child has a legal representative. This would require significantly more child rights representative, of course. But in addition to the children's rights representative that currently exists in Hungarian law, a child rights lawyer could be introduced as a new legal institution, among whom those with such special qualification would be able to support the participation of a disabled child in civil proceedings. The court would be obliged to appoint a children's rights lawyer to the minor child as an interested person if requested by any party, for example, the disabled children person, or by the minor child who has sufficient understanding, or if the court decided to hear the minor child as an interested person in the action. The court could appoint a children's rights lawyer even if it detects a circumstance that makes it necessary for a child's rights lawyer to participate in the proceeding in order to protect the interest of a minor child, especially in case of a disabled child. The children's rights lawyer informs the minor child about the course of the procedure, his or her procedural rights, the procedural acts that affect him or her, as well as the content and the legal effects of the court decision that affect him or her. And she is obliged to be present at the hearing of the minor child and must convey the opinion of the minor child to the court, and the participants in the procedure towards can also make a proposal to the court on the content of the measure or judicial order serving the best interest of the minor child. In addition to the civil proceeding, it will also be possible to appoint a children's rights lawyer in proceeding before the guardianship authority, defining the times of proceeding in which appointment of a children's rights lawyer is mandatory in order to protect the interest of the child, or varies depends on the discretion of the guardianship authority. If a disabled child is involved, the appointment of the children's rights lawyer would be mandatory. In summary, it can be concluded that in recent years, significant progress has been made in Hungarian private law in terms of ensuring the opportunity for children with disabilities to express their view. In accordance with Article 12 of the CRC, the analyzed provision of the Civil Code and the Civil Procedure Code provided the child with the opportunity to express views, with the court being obliged to notify the child of this. This notification cannot be omitted due to the fact that the child is disabled. The Hungarian procedural regulation and institutional background should develop in such a way that the disabled child is provided with disability-appropriate assistance during the procedure in order to be able to exercise their right in a genuine and effective way. Thank you for your kind attention.
Thank you very much. And now I would like to ask our last speaker, Dr. Marta Benius, who will talk in her conclusions and proposals how to improve the effectiveness of application of the principles outlined in the CRC in terms of disabled children, especially the right to life and survive in a loving family environment. Please, Doctor.
Yes, thank you very much. My name is Marta Benius and I'm from the Ferenc Meder Institute of Comparative Law. Let me slightly diverge from the initial topic given in the beginning and use this opportunity to summarize the findings of my research and also to give concrete the lege ferenda proposals for the Hungarian legislator. So my research under the third Polish-Hungarian research platform in the frame of the research group The Rights of Children with Disabilities had two angles. Firstly, it examined the existence and the nature of a child rights-based approach towards children with disabilities, both on a universal level as well as on a national level. And secondly, it raised the question of the necessity of establishing a specialized human rights institution that is particularly sensitive to apply the child rights-based approach towards children on the periphery, such as children with disabilities, and that is the national shaper of a genuine child rights-based approach in Hungarian legal system. In order to have a good regulatory approach towards children with disabilities, the child rights-based approach, and as such, the genuine protection of their childhood is essential. Nevertheless, research showed that all of the elements of this approach are injured, and it is true from a more generalizing perspective, as well as from a perspective of Hungarian law. From a generalizing perspective, discrimination, explicit or hidden, is affecting children with disabilities worldwide. The best interest of the child principle is not applied comprehensively, and the voice of children is not given due weight when determining their best interest, even though these children have the same right to life, health, development, education as their healthy counterparts. They have a bigger chance of lose their life before even being born, to be abused or exploited. Inclusive education is far from being reached when two education systems exist parallelly, one of mainstream education and one that is called special education when in reality is rather segregated. And the right of children with disabilities to spend the childhood in a caring and loving family environment is harmed by tending to institutionalize on the basis of disability. From a Hungarian perspective, the invisibility of children with disabilities is striking as well. However, it is not necessarily something that this derives slowly from the lack of legislation, as we have UNCRCD ratified 30 years ago, as well as the UNCRPD. Indeed, thoughts could be given to make some legislative action in order to have a more deepened national implementation, such as strengthening the voice of children by including the right to be heard. So Article 12 of the UNCRC on a constitutional level, review the translation of the UNCRC and as such, the implementation of Child Protection Act in order to have a wording that reflects more precisely on the actual meaning of the given provisions, and appoint a separate institution that would specifically deal with protection and promotion of children's rights with an attention on children on the periphery. Nevertheless, even the current legislative framework could be sufficient if it was more met by practice. The initiation of a rights-based strategy where the child rights-based approach is applied comprehensively based on research and disaggregated data collection allows targeted comprehensive actions on the national level which are needed. The strategy should consider the 4+1 principles of the UNCRC as elements of the child rights-based approach, and in particular should support the families of children with disabilities, including through financial assistance, increase access to community services that are inclusive of children with disabilities, particularly health and rehabilitation services, transport, leisure, and sports in order to promote their inclusion in society, provide adequate training to child protection workers on the rights and needs of children with disabilities, conduct awareness-raising campaigns to combat stigmatization of and prejudice against children with disabilities, and promote a positive image of children with disabilities, their recognition as rights holders and respect for their dignity and evolving capacities on an equal basis with other children. Collect data periodically and update database regularly. Involve children with disabilities and the parents of children with disabilities in decision-making, and conduct regularly rights-based impact assessments. I came to these conclusions by examining the 4+1 principles of the UNCRC as core elements of the child rights-based approach: non-discrimination, the viewpoint of the child, the best interest of the child, the right to life, survival, and development in a caring and loving family environment as a +1. I also went through the approach of the Committee on the Rights of the Child and the Committee on the Rights of Persons with Disabilities. Nevertheless, I would like to underline as a starting point the second angle of my research, that the child rights-based approach is not necessarily identical with the approach of the CRC Committee, or in terms of children with disabilities, with the approach of the CRC Committee read together with the remarks of the CRPD Committee. Such an approach is, of course, based on the widely agreed and legally binding text of the UNCRC and the UNCRPD, and also takes into account and monitors the interpretative work of the committees and applies it if it can be integrated and pasted into national measures. But the real child rights-based approach on a national level may still be adequate and taking into paramount consideration of the best interest of the children living in the particular country if it does not echo the opinion of the committees. However, in order for the approach to stay genuinely child rights based, it should never conflict the provisions of the UNCRC or the UNCRPD. The subject of the child rights based approach cannot be discussed without highlighting the importance that lays in the national implementation of the UNCRC. The second angle picked up the thread at this point and raised the question on how the national implementation of the UNCRC and the formation of the child rights-based approach may be effectively enhanced for the benefit of children, especially children on the periphery, such as children with disabilities. What is the institutional background that in a good enough legislative environment have the mandate and adequate power and trust of the society, which provides a real chance in forming the child rights-based approach to be a standard also towards those children who suffer from some kind of disability or are pushed on the periphery from any other reasons? I argue that specialized national human rights institutions have the chance to complete this interdisciplinary task if formed correctly and filled with a high level of expertise, and act as national shapers of the child rights-based approach. Local organizations are responsive to community needs, interests, and values, while still remaining open, inclusive, and sensitive, and have the chance through social campaigns to shape the perspectives of society. And as disability is a social concept, it has a very big strength. There is a need, and this is my recommendation, to establish a specialized national human rights institution, which is clearly authorized on a constitutional level to protect children in accordance with Article L, Article 2, Article 15, Article 16, and Article 18 of the Fundamental Law, as well as in accordance with the effective child protection and child rights regulations in Hungary, and to adopt a separate law that provides appropriate authorization and powers for it. The Children's Rights Commissioner or Ombudsperson created independently would be elected by the Parliament and filled with the human resources that has an outstanding expertise on the field of children's rights. The separate law on the Ombudsman would, among other things, strengthen the international role of the Children's Rights Commissioner, especially during the preparation of the report to the UN Committee on the Rights of the Child, and establish an active legal clinic to help remedy violation of children's rights and provide an accessibility for all children. The Ombudsman would be authorized to work together with state and church-run public education institutions in the field of child protection, and would also be authorized to take action against institutions, private entities, if they carry out activities contrary to fundamental law or the UNCRC. In the case of an independently established children's rights ombudsman, the recommendation goes for changing or completing Article 15 of the Fundamental Law as follows. Hungary, to add the sentence, Hungary protects the best interest of the child. This would correct the currently bad and misused translation of the best interest of the child. To add the paragraph that parents and persons responsible for children shall listen to the child opinion and take into account when protecting and asserting the rights of the child, and also take into account the evolving capacity. This would be a pledge of the rights-based approach brought by Article 12 of the UNCRC. As I said, after the constitutional changes or the changes in the fundamental law, there would be a need for a separate law that would provide the legal framework and the operational background of the Children's Rights Commissioner or Ombudsperson. And it should provide, in my opinion, the following powers: a competence of handling individual complaints, competence to initiate ex officio inquiries, competence to turn to the Constitutional Court, to intervene in judicial proceedings, to review draft law, to monitor with an outstanding attention the applicability of the child rights-based approach towards children on the periphery with a special attention on children with disabilities, deal with an outstanding stress with the principle of accessibility, ensure children's participation to gain full membership of the European network of child rights commissioners, and participate in international monitoring. The full reasoning and the detailed information may be read in my articles. I would like to thank all of you for the attention, and as a closing remark, I would like to thank all of you for the opportunity to work together and participate in this project, and I really hope to see all of you in Poland. Thank you very much.
Thank you very much. I think the child rights-based approach, it was a very good summary, not only our last seminar, but generally our almost year-long work. So thank you, Marta. And dear professors, dear colleagues, I would like to thank you for your contribution to this project, for your participation in seminars, excellent lectures, and of course for your studies to our monograph. Of course, I'm still waiting for your articles, and it was a great pleasure for me to work with you. I'm very grateful, but we see, yes, in November. So we see each other at the conference, summarizing conference, and now. Goodbye for all of you, and see you in November.
Bye. See you.
See you.
Evening. Bye-bye.
Thank you.
Bye.
Thank you.
See
Thank
you
you
in
very much.
Warsaw in Love. Live.
Yes.
See you.
In person,
Bye.
yes. Bye.
Katarzyna, czy ja dobrze
Tak.
słyszałem, że do końca października mamy czas na ten artykuł?
Tak.
A, dobra.
Tak, tylko chyba 2 osoby złożyły. Dzisiaj nie pamiętam, czy Zuza mówiła, że ona skończyła
Ona
dzisiaj.
skończyła dzisiaj, no.
Tak. Ja jeszcze nie skończyłam i też będę
No
jeszcze
ja też
tłumaczyć.
jeszcze jestem w rozsypce.
Już się nie wyrobiłam.
Powiedz mi jeszcze, ten raport, co pisaliśmy, ten pierwszy, będzie jeszcze tam możliwość dokonania poprawki. Jak go pisałem, to jeszcze nie weszły te ustawy, o świadczeniach, więc ja pisałem w czasie przyszłym o nich, że one wejdą, że są już uchwalone, czekają
Mówisz
na
o
podpis
których?
prezydenta.
Tych wspierających?
Tak.
Świadczeniu wspierającym?
No.
No
Więc
to może już jak najszybciej co zgłosisz, bo nie pozwoli te poprawki nanieść teraz.
To odezwać się tam do nich, tak?
A nie na etapie korekty. Znaczy
Dobra.
jak chcesz, możesz sam się odezwać, ja mogę się odezwać w swoim imieniu, jak wolisz.
Wolałbym tak.
Dobra, to ja to zgłoszę może tutaj Agacie czy Zbyszkowi Więckowskiemu i powiem z jakiego powodu, nie? Że to jest kwestia po prostu naniesienia poprawek z uwagi na zmiany.
Na zmiany legislacyjne.
Wiem, bo ja też ustawę, jak pisałam komentarz do ustawy o systemie ubezpieczeń społecznych, oczywiście w grupie tam wielu autorów, to akurat mi przypadł ten fragment dotyczący opiekunów i po prostu oddałam tekst w lutym, a mi w wakacje nie zmienili.
No, tak to jest.
I poprawki.
To dzięki.
No to jesteśmy już w takim razie. Fajnie, dzięki bardzo.
A powiedz mi jeszcze, którego mamy tą konferencję?
15-17, ten program chyba był nam wysyłany, ja nie pamiętam kiedy my dokładnie występujemy, ale wydaje mi się, że on jest taki dosyć długi.
Dobra.
Długa jest ta konferencja 15-17.
Dobra, dzięki wielkie.
Nie powiedziałam im, że wszystkie koszty, no bo ty też pewnie przyjedziesz, wszystkie koszty Instytut powiedział, że pokrywa przyjazdu i tak dalej.
No to super.
No, to jak coś, to dzwoń.
Dobra, dzięki, spokojnie.
Dziękuję, do zobaczenia, hej.